Well, hello. It's great to see you all again. It's Bill Froelich with my friend and colleague Amy Schmitz at the Ohio State University Moritz College of Law, and we're delighted to have our friend Tina Patterson, who is the principal of Jade Solutions, here with us today for our third video series and column in Mediation. So, of course, Tina is an international arbitrator, and she specializes in fintech, technology, IP, and in domain name disputes. And she brings a combination of payment systems and expertise and 2 decades of ADR experience, having handled nearly 300 arbitrations across financial services, technology, and commercial matters. I know her from working with the ABA section of Dispute Resolution's Public Policy Consensus Building Subcommittee. And so she's done a lot of work there, and I've been following her as she's been thinking about AI and mediation.
Yeah, I'm just so excited to have you with us, Tina. We've been friends a long time. I really know that you know your stuff. You've been in this field for a very long time. And, I know that you've talked about different ethical conundrums that mediators have when we think about AI in mediation. Would you mind sharing those?
Sure, and thank you for having me, Amy. It's wonderful to see you as always. I'm going to talk about three conundrums that I see regarding their ethical conundrums for AI, artificial intelligence, and mediation. And let me start with the framework. As mediators, we build our practice on confidentiality, informed consent, and impartiality. AI challenges all three simultaneously. That's not a reason to reject AI. It's why we need to think carefully about where and how we use it. So let me start with conundrum number one, which is related to confidentiality versus machine learning. And the tension lies with AI tools learn from data that you feed it. Mediation requires absolute confidentiality. How do you use AI without training it on confidential case information? So questions for the mediator, or that they should be asking themselves: does this tool share my data? Is my input used to train future models? Where are the servers located? Jurisdiction matters. Can I use AI for case preparation, but not live mediation? So a real example might be, I can use AI to research industry trends before mediation. I cannot paste confidential information offers into ChatGPT and ask it to generate counter offers. The line seems obvious, but I've heard of mediators crossing it. Conundrum number two, informed consent. Do parties know? And here's where the tension lies. Parties consent to mediation with a human neutral. If a mediator uses AI for any part of the process, do parties have the right to know? The third part of this triangulation and tension is, where's the line between mediator's tool and participant in process? So some questions to consider for the mediator. If I use AI to draft the mediation agreement, must I disclose that? If I use AI to analyze settlement patterns, is that my professional judgment or AI's? What if one party is using AI and the other isn't? Does that create imbalance? My position on this is transparency is safest. If AI touches any party facing document or influences my process, I disclose it. Better to be communicating too much or over communicating than to lose trust. And then conundrum number three, which is bias amplification. And here's where the tension is, from my perspective, again, a triangulation. AI models trained on historical data replicate historical biases. Mediation aims to level power imbalances. And the third part of that triangle is AI could inadvertently amplify them. So here's some real risks to consider as mediators. Predictive settlement tools trained on cases where women, minorities settled for less. Language processing AI that interprets assertiveness differently by gender and or race. Risk assessment tools that disadvantage parties without legal representation. So what mediators need, we need to ask, whose data trained this model? If I'm using AI to assess reasonable settlement ranges, and I'm putting quotes around reasonableness, am I just replicating past discriminations at scale? So those are my three conundrums.
Yeah, those are really good and they're really important. I tremendously agree, and over disclosure is best for sure. You know, when you think about those conundrums, right, and you put yourself as you are a mediator, an arbitrator, a neutral, um, it's scary out there, right? So, what practical advice do you have?
Oh, sure. So I got a couple. One is create your ethics framework now. What will you use AI for? Will it be research, scheduling, admin? What's off limits? Confidential info, settlement recommendations. Document your boundaries. My second guidance point would be disclosure as default, telling the parties, I use AI tools for scheduling and research and pre-mediation letters. Be specific about what AI does and doesn't touch. Stay current. And I know there is an overwhelming amount of information, but stay current on what's going on to the best that you can. Join discussions such as this one or through other groups such as the American Bar Association or the Association for Conflict Resolution, and also consider state bars and local bars. What's acceptable today may not be tomorrow. So stay current with what's going on and look for guidance or some type of documentation that will provide more details. And then technology changes faster than ethics rules. So make sure you're aware of what the ethics rules allow you to do and not to do. And then my fourth guidance would be, remember, you're the fiduciary, not the tool. AI is your assistant, not your co-mediator. You remain responsible for every decision. And saying the AI suggested it is not a defense.
Yeah, absolutely. No, I think those are really good practical guidance. Really hard to keep up on sort of understanding the benefits and risks, but that's absolutely part of your duty as a neutral, as an attorney, as in any professional area when you're using AI. I mean, it's really important to understand the tool you're using, right? I like to say,
Absolutely.
you don't use a hammer when you need a screwdriver, right? And really being able to collaborate with that tool and
Yes,
not give your duties away, right? No, that makes a lot of sense. Well,
absolutely.
yeah, no, this has been great. I'm really, really thankful that you took time with us, and these are really helpful. I hope people really take it to heart because, with this column and with this podcast, we really do want to think about ethics and ethical use of AI and want to keep providing these sort of practical tips. So, thank you, Tina. I really, really appreciate this.
Oh, you're very welcome. And just one final note, what gives me hope? What gives me hope is that mediators are having these conversations now before rules are mandated, before disaster strikes, and they're building their ethical foundation now for AI enhanced mediation. We have a chance to do this right, to use AI to expand access to justice without sacrificing the human judgment that makes mediation work.
Oh, I love that. I'm going to leave it there because that's a perfect way to end. Thank you. Have a
You're very
wonderful
welcome.
day.
You too. Take care.
Bye.
Bye bye.